untenable under Article 32 of the Constitution, as it involves violation of fundamental rights under Article 4. Concerns a dispute arising out of a marriage between parties and circumstances where it was entered into. Briefly, the petitioner, Sangeeta Malhotra, is a software engineer employed at Innovation Solution Private Limited, a company which introduced a program offering incentives such as in the course of her employment, the petitioner was exposed to workplace interactions associated with the said program. Subsequently, in March 2023, petitioner entered into a marriage with her colleague, the respondent Rohit Khanna, in accordance with the Hindu Marriage Act. Upon executed by the petitioner. The petitioner initially approached the family in the light of the fact presented, Your Honor, the following issues arise for consideration. Issue number 1, whether corporate incentives and workplace pressure amount to undue influence violating free consent. Secondly, whether entering into such a marriage violates the petitioner's fundamental right under Article 14 and 41. Issue number 3, whether the petitioner is maintainable before this honorable court. With your time permission, Your Honor, I will be addressing issue number 1, 2, and 3, and the remaining issues will be dealt with the prayer. Now, issue number 1, which deal with whether corporate incentives and workplace pressure amount to undue influence violating free consent. That consent under law must be free and voluntary. In this present case, the petitioner consent was influenced by economic and psychological pressure arising out of a marriage program. Secondly, the employer and employee relation creates an placing is sufficient under law. Your Honor, when career growth, benefits, and preferential stanching are indirectly linked to whether entering into such a marriage violates fundamental right under Article 21. It is respectfully submitted that the petition Article 14 and 21. Article 21 guarantees personal liberty pressure. Further, the corporate policy creates an arbitrary classification by linking the marital status with professional benefits, thereby violating Article 14. Marriage must be a matter of free choice, not a consequence of institutional pressure. Has recognized the matrimonial relationship must be based on free will, dignity, and mutual respect. That circumstance should not involve any coercion or any pressure unless autonomy undermine very foundation of marriage. Proceeding with issue number 3, which deal with whether petitioner is entitled to maintenance under section 125 CRPC. Respectfully submitted, Your Honor, the petitioner is entitled to maintenance under section 125 CRPC and protection under Domestic Violence Act, as these are beneficial legislations aimed at preventing destitution and dignity. As maintenance is about need and dignity. It does not matter how the marriage took place. The purpose of ensure women my Learn Co-Council to proceed with the remaining issues along with the prayer.
And they want to take the benefit of the corporate
that you have raised the issue in front of me. The case that was created by the company and the Rohit itself. Completely free will. Her decision was shaped by workplace pressure and economic independence. Your Lordship, here employer and employer economically dependent on the company. I would like to quote a case here. Narayan Ganesh Dastane, Sucheta Dastane, mentioned in petitioner's memorial, page number 12, para 1.1, where Honorable Supreme Court has already recognized that coercion is not just physical, even mental and psychological. Case. Further, mentioned in page number 12, 1.2 paragraph. The court clearly held that where one party has dominant power and the other has no real choice, the consent cannot said to be truly free. Here, the precisely situation is Sangeeta was economically dependent. There was a clear structure influencing her decision, and refusal could have affected her professional life.
But if we will see that she's working in a company and she knows every possible effect and we can say the further future intrications. So what about that? Because she also signed a contract agreement to take the benefit.
Your Lordship, education and employment solely does not bar that she could be denied relief here. The decision was not taken. It itself recognized by is wholly solely recognized in section 16 of Indian Contract Act, which is exactly what has happened in petitioner's case. With due permission, Your Lordship, I would like to invite my Learn Co-Counsel. Much obliged, Your Lordship.
With due permission, Honorable Court, I would like to proceed with the remaining issues. Issue number 4 talks about whether the marriage is void or voidable. Your Honorable Lordship, it is respectfully submitted that the marriage in the present case is not void ab initio. It falls under the ambit of Narayan Dastane versus Sucheta Dastane on page 19, para psychological pressure is enough. This is what exactly happened here. Now, the other side may argue that the marriage is not really to continue on marriage, he must never enter that the consent is affected by subject to judicial scrutiny. Therefore, the marriage is voidable and liable to set about whether the company can be liable. Work environment which directly influenced her personal marital decisions. The corporate policies that interfere with individual autonomy and dignity cannot be sustained under the law. Employer and employee relationship in bargaining power. Any policy that exploits such imbalance affects, attracts, 21, para 5.2 when position and has no real choice. Situations are unfair and cannot be sustained under the law. Institutional influence over personal decisions cannot be justified under the guise of professional incentive. Your Honor, when one Your Honor, now I would like to proceed with issue number 6, which talks about whether the petition is maintainable before the Honorable Court. I respectfully submit that the the jurisdiction of the Honorable Court, where fundamental rights are violated. The present case involves a substantial question of law relating to personal liberty, equality, of constitution remedy. I would like to quote a case of Ramesh Thapar versus State of Madras on page number 22, para 6.a. The Honorable Supreme Court has already held that the right to approach this court is also quote a case which copy has been provided for your convenience. Shilpa Shailesh versus it may directly entertain and decide matrimonial dispute, even without the party first approaching the family court, in order to do complete justice. Thus, the existence of alternate remedies do not an irretrievable breakdown of marriage. Therefore, the present case, according to the present case, this Honorable Court has authority to and grant relief to the petitioner. Your Lordship, if you have no question, I would like to proceed with the prayer of the case. Sure, much obliged. Most respectfully prayed that the Honorable Court may be pleased to declare the marriage voidable under Hindu Marriage Act due to lack of free consent, grant maintenance and relief under Section 125 of CRPC and PWDB Act, uphold that policies and practices that violates fundamental rights like Article 41 and 21 violate compensation and guidelines. Any order justice and good conscience. The Council, on behalf of the petitioner, is grateful of this honorable court for the time and consideration.
My first question is that you have added that there is no real choice before her to accept the marriage. So, in case there is no salary curtailment, if she will get married or she got married,
Yes, sir.
not
Yes, ma'am.
any curtailment of any benefit earlier she was getting. So where we can say there is no choice.
That the petitioner is a motivated person. Because of the policy, she was
That is so, and they have touched Article 14 also. So how we can say that 14? How we can say that Article 14 because everyone have a right to equality.
Your Lordship, in the present company, they discriminated between the married and the unmarried. Article 14 here the company only provided incentives for married couple, not unmarried couple. And the unmarried couple was feeling coerced and under the influence that if they did not participate, they will not get the benefits. So yes, the consent was coerced. The petitioner was under the influence of the company and the coercive environment that the company has made due to the policies.
Last question only.
Yes, my lord.
Okay, no doubt we went to Honorable Supreme Court for this one, declaring marriage void or void of an issue under Section 12 of the HMA. We are also and domestic violence.
Does not have the original jurisdiction to settle it because the family code deals with such matter, but here the matter is more about the constitutional validity and the constitutional rights that were violated of the petitioner.
That I agree.
So the
That
petition,
but-
so the
but-
yes, my lord, sorry.
So from or protection from the Honorable Supreme Court.
Your lordship, here we cannot directly claim it, but it does include the violation of fundamental rights, so we can directly approach according to the case of Srinivasam. She did not approach the family court first. She directly approached Supreme Court, and Supreme Court provided her remedy under Article 142 of the Indian Constitution.
And who has a original jurisdiction of 125 CRPC? But domestic violence code, for your knowledge, that is so
Thank you so much for enlightening me, sir. Thank you so much. Thank you so much, judges. Thank you.
Thank you.
When the advocate is not clear about the facts when the question was posed to her, so rather than saying I am little confused, she can always say that she can get back to the honorable court with the fact little question was to the confused that she could have said that she will get back to honorable court with the fact little later rather than saying I'm little confused. Is that correct observation?
Because whenever we are saying in court, whenever we are submitting anything, our main thing is that when we knows everything that this is wrong, another aspect is demanding the effect of I would like at here, but I should not. But because in this
May it please the Honorable Court, I appear on the behalf of with my learned co-counsel, that is Speaker 2. I'm grateful for the opportunity to present lordships. May it please the Honorable Court, the present matter arises out of a matrimonial dispute between the petitioner, Ms. Sangeeta Malhotra, and respondent number 1, Mr. Rohit Khanna, both employed as software engineers at company number 2, a private company. The company produced a voluntary corporate marriage program without imposing any obligation. Thus, the parties, being colleagues of mutually decided to marry and the petitioner had also executed a written consent acknowledging her voluntary decision. Subsequently, due to personal differences, disputes arose between the parties, and the petitioner later alleged that her consent was vitiated by workplace pressure and sought reliefs, including declaration of nullity of marriage, maintenance, and protection under statutory laws. It is the respondent's respectful submission, my lords, that these allegations are an afterthought arising from matrimonial discord, and that the present Article 32, despite the availability of alternative remedies. My lords, the following issues arises for consideration before this honorable court. Whether corporate incentives and workplace environment constitute of the whether entering into marriage in light of corporate policies amounts to violation of fundamental rights under Article 14 and 21 of the Constitution, whether the petitioner is entitled to maintenance under Section 125 CRPC and protection of PWDVA Act, despite entering into the marriage, whether the marriage in question is void, voidable, or legally valid under Section 12 of HMA, whether respondent number 2, the company, can be held liable for allegedly influencing personal marital decisions through its corporate policies. And issue number 6, whether the present petition